Supreme Court will this afternoon deliver in detail why it upheld President Uhuru Kenyatta's win in the contentious repeat presidential election. And political affairs reporter Murimi Mwangi now highlights key issues that the Supreme Court has to answer and explains why some legal experts want the presidential petitions framework reviewed.
As Uhuru Muigai Kenyatta and William Samoei Ruto donned the 2013 caps as president and deputy president respectively, following the first election under the 2010 constitution, two members of the inaugural Supreme Court bench, Justice Mukin Wanjala and retired Chief Justice Will Mutunga, shared critical lessons on the abrasive brand of Kenyan politics and the divisive nature of presidential poll petitions.
The nature of our politics is very ethnic. It's very fractional. Okay, they use everything. It's ethnicity, they use religion, they use race, they use region, they use clan.
In Kenya now, from my view, whichever way you decide on a presidential election petition, you will annoy half of the Kenyan people, and you will really make another half very happy.
And this is the exact state of affairs in Kenya, as the Chief Justice David Maraga chaired 6-judge bench, also comprising Justice Wanjala, prepares to explain in detail why it upheld President Kenyatta's re-election in the contentious October 26 repeat presidential poll, boycotted by his arch-political nemesis, opposition leader Raila Odinga.
From the threshold, there is no anxiety about tomorrow's decision, both from the Jubilee side and also from the NASA side. Reason being, Jubilee has already procured processes to enable it start the formation of government.
Confronting the judges is the query on legitimacy of the outcome of an election that was postponed and later cancelled in 25 constituencies, a move which petitioners Halef Halifa, Njonjo Mue and Harun Mwau separately argued had contravened Article 138(2) of the 2010 Constitution that seemingly necessitates the conduct of a presidential election in each of the 290 constituencies.
It can logically be asked, the citizens in those 26 constituencies that did not vote at all, are they obliged to recognize the presidency of Uhuru Kenyatta? That's a valid question.
There is no perfect election. There will always be errors in an election. But you cannot invalidate an election unless those errors and discrepancies are of such a nature as to affect the actual outcome. That is the law.
No reform, no elections. But arguably the most eagerly awaited explanation from the judges is the legal implications of Odinga's October 10th decision to quit the repeat poll, demanding for a new election preceded by fresh nominations in 90 days. A move which was subsequently followed by High Court Judge John Mativo's verdict, ordering inclusion of Third Way Alliance leader Dr. Ekuru Aukot on the ballot, giving a leeway for other fringe candidates from the August general election to also run in the repeat poll.
If the law indicates that all matters presidential must be handled by the Supreme Court, on what basis could the IEBC have relied upon a decision of the High Court to include other candidates?
Issues that may be now remaining are political questions, which, of course, the people who have interest in those issues might want to justify their actions through the Constitution and the laws that we have. But it is a question that probably the Court of Laws might not resolve.
Now, even with the presidential petition out of the picture, the political dust kicked off by the contentious repeat presidential poll, it appears, will take time to settle, even as Kenyans await the full version of the judgment. Murimi Mwangi, KTN News in Nairobi.